Judge Judy. Love her or not, she's a straight shooter and she's extremely knowledgeable about the law. I always find it interesting to see shows of Judge Judy for real property or for land and real estate with Judge Judy. It's fun to watch. Here's a great episode, and it is a great lesson for all of us. When Judge Judy talks about contracts specifically, she really knows what she's talking about.
Mr. Piscala, I know that this is going to come to you as very bad news, but one of the first things that I learned in law school when I took real property is that any time you transfer real property, that has to be in writing, signed by both parties. That's the only way you can transfer real property.
Yes, ma'am.
This is something that I actually see a lot, believe it or not. When you're inside of a transaction, many times people will talk about, oh, let's just do this or let's do that. One thing that I've learned over time is that unless it's in writing, it doesn't exist. There's no way to actually hold it up.
You entered into an oral agreement with the defendant to purchase some property that she had, and you entered an agreement to buy it for, just give me the amount.
$38,000, Your Honor, for 8.35 acres.
And you entered into that agreement with her, just give me the month and year.
We agreed on that in January, the second week of January,
Of this year.
2017.
Okay, and then before you had a written agreement transferring the property, you went on the property, you say, with her permission, just to do some clearing away of brush and debris and making it so that you could use it. What was your intention to do with the property?
Our intention was to start a small working farm with this property.
Okay, and then the deal was never consummated.
Correct.
In this instance, it doesn't help him if it wasn't in writing. If it was in writing and it was contingent, there's some different ways to create that on both sides. It could be contingent against financing, against him inspecting the property, even an appraisal. But if there's no contingency and there's nothing in writing, you're going to have different opinions on both sides.
We had an oral agreement to work on it while the lawyers were actually working on the agreement.
No, you asked her if you could work on the property.
If you have attorneys working on your behalf, it's very simple for the attorneys to write up a draft if everybody is on the same page and on board as far as him going and clearing the property or getting the property ready in contingent of her selling the property to him.
I believe it's only fair that I be repaid for the work and labor that I put into this land under the false pretenses of being sold this land.
You're not going to get it. You chose to go on the property before the property was sold and do work on the property. If I believe, which I probably think is true, so I'm going to dismiss that counterclaim, which I probably believe is true, that you said to her, by the way, do you mind if I go in and start clearing away the property since we have a deal? Okay? I probably believe that you said that to her. And she said, I don't care. We're fine. She didn't say to you, fine. And if we don't consummate the deal, I will pay you $11 an hour for whatever work that you do on the property if it enriches my property. You don't have that contract. So there is no theory upon which you get paid for clearing away her property.
Your Honor, I'm not a charity. I work for a living, and the time that I worked on this land...
Then you should have waited. You're not getting paid. There's no legal theory, sir. What you should have done was wait until you had a contract signed, turning over the property to you.
I went and contacted the property owner, and she said she was going to rehire another attorney. In the process, she gave us permission to work on this land.
I told you, listen, Mr. I'm not arguing with you. I don't know why you're arguing with me. You're just not going to get paid because you were smart enough to give me the correct answer. You knew that the only way to transfer property is by transferring a deed to the property. That has to be done after a proper closing. You
I understand,
know that.
Your Honor.
You know that. You know that. And anybody, listen to me.
So if this was the case, if he was in the position where he was going to go and work the property before the property was sold to him and before everything was completed, on his side, this is something he could have put into that contract. So when you're looking at the contract, it makes perfect sense on both sides. She has the right to sell it to a higher party, to a higher offer, if that's the case. You can have a contingency on the seller side as well as the buyer side. It just doesn't have to be one way. typically, when we're looking at an agreement and we're looking at a purchase or a sale, it's typically going to be on the side of the buyer, not of the seller. However, in this type of scenario, it's a contract, and that contract can be written however both parties agree to it, as long as it's lawful.
And now with the judicial system, but I'm turning the corner, and I'm saying to you, let's say you decided after 3 months of negotiating with her lawyer that you made an offer that was $10,000 too high, and that you could buy a neighboring piece of property for $25,000, the exact same piece of property. So you called her lawyer, or your lawyer called her and said, we've decided not to sell the property. You think she has a right to sue you? Sue you for the 3 months that the property was off the market because you were negotiating an agreement? The answer is, if that happens all the time, and deals fall through. So she wouldn't have the right to sue you.
I understand that, Your Honor. The real estate deal itself is null and void. But the work that was performed, I feel I should be paid for.
I don't care what your feelings are. We don't deal with feelings. Feelings, you go to Dr. Phil.
I'm not a charity, Your Honor.
Here we deal with the law.
I work hard for the money that I earn.
Just a second. You didn't earn any money.
I did perform 200 hours of labor on this land.
Then you are a charity because you're not getting paid for it. A, did you relist the property? Question.
Yes.
Did you relist the property? With what realtor?
It wasn't with a realtor.
With whom?
It was private. It's with a gentleman down the road.
Just a second. Did you consummate that deal?
Yes.
You consummate for how much?
$115.
This is interesting because there is an argument to be made here about if that property was cleared by him, did that raise the value of the property? So he may be upset about that as well. Or maybe it's just a point that hasn't been made.
It's 2 pieces of property. It's 115. So I want to say 60,000.
Just a second.
75,000.
Did you sell it to the same person?
Yes, the same
so
person.
So you sold the same person 2 parcels of property that you own.
Correct.
And how much property altogether is it? How many acres?
It would be 12 acres.
And he was buying 8.
Yes.
Is that what 8
Yes,
and
right,
change?
8.35.
So you sold 12 acres to somebody for 115.
The total of both is 115, Judge.
The total for both
for
was
both.
115.
Correct.
For the 8-acre parcel that he was going to buy.
Yes.
Right?
Yes, and the 2.2.
For 38, and for another 4-acre parcel.
It's 2.2. I'm wrong.
Whatever it was less
Yes.
for 115.
Correct.
You almost got a good deal, but you didn't. Case is dismissed. We're done.
I'm not an attorney. I do work with a lot of contracts, and this is certainly one thing that I've learned is make sure that it's in writing. And especially since that was 8 acres that was cleared, that he cleared out, and an additional 4 acres. She said 12, she said a couple different things, but additional 4 acres and she sold for 115. My bet is that he cleared that property and somebody else came along and said, hey, that's a nice property. I would love to own that, and I'm happy to pay you more. Hope you're having a great day. Talk to you soon.